right, so defendant was previously arraigned, failed to appear at his probable cause conference, and it resulted in a warrant revocation. So we have these two cases in front of me. On the domestic violence, he had a $5,000 cash bond right now. And defense counsel did file a motion. He came in on a date last week, but it wasn't a state date, so I didn't have the proper prosecutor ready to address bond. What do the parties want to tell me about bond?
Your Honor, I don't believe that we were able to come to an agreement, so I'd be happy to argue my motion. This court would be
okay.
Your Honor, I'm going to object to any type of modification to the bond. If you, I don't know who you wanted to hear first.
Well, no, I'll hear his motion and then you can respond. Go ahead, counsel.
I'm not going to belabor this point because this will be the third time that I've made my points in front of Your Honor. I have no doubt that Your Honor reviewed my bond motion. I'm sure Your Honor remembers. Last week, I believe it was Wednesday, when I made several points about why Mr. Coleman should be released. But I will bring one additional thing to Your Honor's attention, and that's Michigan Court Rule 6.106, which explicitly outlines when when the court may deny pretrial release to an individual. Now, of course, Your Honor, this rule does pertain to arraignments, and I understand that Mr. Coleman was previously arraigned. However, I believe that the policy is still sound. And the policy explicitly written here is that the defendant, in order for the court to deny pretrial release, must be charged with murder, treason, must be charged with criminal sexual conduct in the first degree, armed robbery, kidnapping, or must be charged with a violent felony and must have had a violent felony in his past. And while we recognize that these allegations, which is all that they are, Your Honor, amount to a violent felony and the assault with intent to do great bodily harm less than murder, to the best of my understanding, Mr. Coleman has nothing in his criminal history that would rise to the level of a violent felony. And as a result, to remand Mr. Coleman would go against the sound policy written into that court rule. I'm asking Your Honor to please release Mr. Coleman with a tether, because I believe that the tether will accomplish the two goals that this court has to consider when evaluating bond: community safety and likelihood of having Mr. Coleman return to court. Obviously, Your Honor well knows why the tether would keep Mr. Coleman from absconding. The moment that he does, he would be picked up immediately. But again, I will remind the court, as I spoke about last week, that in terms of community safety, I have no doubt that the court's concern is keeping this individual, complaining witness, safe, and an exclusionary zone on her home, work, any area frequently visits would ensure that Mr. Coleman has absolutely no contact with her, keeps her safe, and again, ensures that Coleman returns to court. I do believe the court can accomplish its goals by releasing Mr. Coleman on a tether, and that's exactly what I'm asking the court to do. Thank you.
All right, so I want to be clear, because I looked at this file, Mr. Wittenoff, after you were here last, because the bond did not make sense to me, and it's because he failed to, the reason it was set at no bond was simply our system does that when someone fails to appear, and then bond has to be reset. So the only reason he was on that bond was because of his failure to appear at the PCC. Counsel, I don't need your response. I'm familiar with these files. And quite frankly, I just do not believe that a personal bond is appropriate, or even a low cash bond. The allegations in this case are alarming, and I have significant concerns for the complaining witness. There was a domestic violence that was alleged to have occurred on January 28th through 2025. It's my understanding that the parties separated in between that date and the next date, and the allegation is he was not residing in the house, and that the complaining witness woke up and had a feeling, if you will, that someone was in the home. And the allegation is she tried to call 911 and the allegations, the defendant snuck into her home and was lying on the floor next to her bed and then got up and started strangling her and telling her he was going to kill her. They're allegations, but they're frightening allegations. And I don't see how a personal bond is appropriate under those facts.
Your Honor,
Yes,
if I may, in regards to the tether,
yeah,
because I know that he was asking for a tether. I did speak to the complainant on Zoom before this hearing. She advised that on the date that this allegation occurred with the strangulation.
Can you talk louder? I want to make sure
On
defense.
the day that this strangulation occurred, she had advised that he was actually on tether for a previous case that was already open. And, you know, again, I would object to any type of bond modification. It seems that he doesn't really follow court orders, especially given that this is the first time we're here after he did not appear the last couple of times.
Your Honor, if I may just briefly respond.
Go ahead.
Your Honor, I appreciate the prosecution's point, I do, but I question whether or not the tether that she just referenced had a specific exclusionary zone for this individual's locations. And Your Honor, I understand that the court is disinclined to give a personal bond. We would ask that this court give a monetary bond with a 10% provision that Mr. Coleman can afford to give this court, so he may show this court that he wants to comply with its orders. He is very, very serious about fighting these allegations and wants to come back to court, Your Honor.
All right. What kind of bond was he on? What was the tether for?
It looks like, I believe, nice retail crime, that there was a case opened on March 25th, 2025. I believe that was the case he was on tether for. But regardless, even if her location was not restricted to tether, he still committed a crime on that tether. And I think that's enough to show that he doesn't commit to following a court order.
Yeah, I'm just incredibly concerned for the complaining witness. These are allegations, but until I hear testimony, I'm just not inclined to give low cash bonds with or without a tether. On the domestic violence case, he has a $5,000 cash or surety tether with a GPS tether, and we'll set that pretrial for 8/18. And then on the felony, he has a $100,000 cash or surety bond with the GPS tether. And at the exam counsel, if you want to, once I hear testimony, if you want to readdress bond, I'll do so. The exam will be August 18th at person at 11 a.m.
Thank you, Judge.
All right, we're all set. And we'll see everyone back at that day. Is discovery complete?
As of right now, yes, but it is still ongoing.
Okay.
Whatever comes up, I will send out.
All right, we're all set. I'll see.